All right, so what I want to talk about today are the cases that we have assigned for employment law. But before that, let me go over our schedule. Today we're going to talk about those two cases. Those are on your quiz for this unit. I'm going to do some final exam review, and then I'm going to go over kind of how I formatted the exam for spring semester and read you some of the answers that were good, some of the answers that were bad, to sort of give you an idea of what you're going to see on your exam. So we'll talk about that. You have a quiz due Monday night on the employment law unit. Your second part of your career prep was due Monday night. I'm pushing that out through Friday of next week, just to give you an extra 4 weekdays, just in case anybody needs it. So if you haven't gotten everything done, you've got a couple extra days on that. You do have an assignment due Monday night on the guest speaker. So most everybody here, most everybody in this class was present Tuesday, but not everybody. So if you didn't, please watch the video, because there is an assignment due Monday on the guest speaker. And I messed the video up in the middle, so it's in 2 parts. I had to start recording again, so that's why it's like that. And there might be like a 5-minute gap or something in there, but just make sure that you pay attention to that. Next Tuesday, we will not have class. And then we do not have any new content for next week. I was going to do intellectual property, but I think we're going to bag that. So no class next Tuesday. We will have a guest speaker next Thursday, but it will be during my 11 o'clock class period. It'll be down in the auditorium where we were Tuesday. If you have a conflict with coming at 11, that's fine. I'm not counting it against you attendance-wise, but I would really appreciate if you could come at 11 to just come at 11. Our guest speaker on Tuesday was awesome, maybe one of the best I've ever had. So I appreciate James. Thank you again for getting your dad up here or down here. And so that was really cool to hear sort of his story and his entrepreneurship journey and some advice he had for y'all. The speaker I've got for next week is a person who just graduated law school and who works for a federal judge here in Columbus. So he's going to tell you kind of how he got where he is, what law school is like, what it's like working for a judge, some of the cool things that he's seen like in trials, and y'all can ask him any questions that you want to ask him. So I think that'll be pretty cool too. So really this will be the last time we meet at 9:30. Everybody clear on that? Okay. Any questions on any of that? All right, let's jump into our cases. So the first case, go ahead, Jason.
When is the exam?
So the exam does anybody have it in front of them? I'm going to make it go live like Monday or Tuesday of Thanksgiving week, and then you'll have 10 days to do it.
Okay.
The exam is take home, and it's open note, and it is locked down browser, but it is open note, open material, and you'll be able to do it at your convenience over 10 days.
Okay.
So, good question. And I'll talk more I'm going to sort of tell you the format when we get there. All right, let's do Bostock versus Clayton County. So, this is a relatively recent case. When I first assigned it, I think I wrote in your notes that it was decided this summer, but that was 4 years ago. Still a recent case. And it involves Title VII, the Civil Rights Act of 1964. And it originated out of Georgia. So let me ask y'all then a few questions. And let me pull up my questions. Where's my questions? And the one day we moved around to the front of the building for class, they were banging right outside
No.
my guest speaker's head. That was awesome. We can't win.
It's
All right.
probably gonna be like this for like a year.
You
I
think
heard it's
so?
supposed to be like this for a year.
Oh, really?
But-
So I just need to stop bitching about it.
No, that's not why. That's not why.
I know I need to. I can't help it.
No, I've complained too.
There is sunlight in my office now.
Even on Tuesday, I was like, really, like, dang, that's why.
They
I'm
opened
like,
the office and they didn't lock it.
They did what?
They opened our office and they didn't lock it.
And they didn't lock it.
Yes.
Yes, same for me. I walked up, but there's nothing in my office is completely empty.
And last couple of weeks, I lost my headphone. It was like $100.
Somebody stole your headphones out of the office.
Yeah, I put it in my office because it's usually work with my headphone.
That's terrible.
Yeah. we
That's a
tell the
crime.
We tell the police, but I don't know if they're gonna do anything or not.
No. So yeah. So I'll probably still be complaining about it next semester. All right. So who are the parties in this case? Let me get y'all through these cases. Who sued who?
Bostock's sued Clayton County.
All right. Who's Mr. Bostock?
Child welfare service coordinator.
Yeah, he worked for DFACS basically. Worked for the state of Georgia, a state employee in Clayton County, Georgia. Anybody here from Clayton County?
Okay, but I'm not from
There you go. So Miss May knows all about Clayton. Clayton County is,
South, like,
it's not McDonough.
no, it's like Forest Park.
That's right.
Morrow.
Morrow. There you go. Forest Park.
That
Morrow.
little area of South Atlanta.
South Atlanta, not far from the airport, I think. Okay, down 75 a little bit. All right, so he sued Clayton County. What happened to Mr. Bostock? Why did he sue Clayton County?
Allegedly, he was fired because he was gay, which constitutes discrimination.
All right, he alleged that he got fired for being gay. Who decided the case, and we'll come back to that, who decided the case that we read? What's the court? From the opinion that we read, what case is that? Court is that from?
U.S. Supreme Court.
Yes, the U.S. Supreme Court. So this made it all the way up to the U.S. Supreme Court. Did it start in the U.S. Supreme Court? No, it would have started in lower courts, right? And then we would have appealed, and that's how we would have gotten to the U.S. Supreme Court. What is the law that's involved in this case?
Civil Rights Act.
Right? Title VII, Civil Rights Act of
It's 1960.
1964, right. And that's going to be important to us. This law was passed and written in 1964. So, you're correct. He got fired, and he says it was because he was gay. So how does that violate Title VII of the Civil Rights Act of 1964? How does he say it does? Title VII protects what? Discrimination
From gays.
on the basis of...
Race, color, national origin, sex, and religion.
Right. That's what it spells
He's
out.
arguing that it fell under sex.
Good. Because the law doesn't say you can't discriminate on the basis of sexual orientation. The law doesn't specifically say that. The law does say you can't discriminate on the basis of sex. And that's the word that's at issue in this case. Mr. Bostock says sex includes sexual orientation or gender identity.
Yeah.
And the employer says, no, it doesn't. Because Title VII just says sex, and we read that to mean male or female, not orientation or identity or anything like that. That's the issue in this case. Does Title VII prevent discrimination on the basis of sexual orientation? That's the question that the court is presented with. So Justice Gorsuch wrote the majority opinion, and he is one of the, Gorsuch I think is a Trump appointee from the first Trump presidency. He's a conservative justice, but he wrote the majority opinion in this case. And let me skip to the end real quick. What did the majority say? Does the word sex in Title VII include sexual orientation?
Are you talking about in the Supreme
Yeah,
Court?
did the Supreme Court read it that way?
Yeah.
They did read it that way. So based on this decision from 2021 forward, The law is that this 1964 law, anti-discrimination law that we had, does prevent discrimination on the basis of orientation. Whereas before that, the law was what? Did Title VII protect that before this decision? It didn't, right? So this is another case. We've looked at a couple of them this semester where the court overruled precedent and changed what the law is. All right, so the beef, the rub, the difference between the majority opinion and the minority opinion, or the dissenting opinion in this case, is not really whether or not we should protect from discrimination based on sexual orientation. The rub between the justices is whether or not this particular law, as it's written, protects from discrimination on the basis of sexual orientation. So the justices use different rationale in how they interpret the law. The majority opinion starts out by saying we have to look at the word sex, the text of the law, what they actually wrote. We got to look at it in the context of 1964 and the ordinary plain meaning that that had at the time. Okay? The dissenting opinion, the disagreeing opinion says there's no way you can tell me that in 1964 those lawmakers wrote sex in there and meant to include orientation or gender identity and those type of things. They meant you can't fire somebody because they're a woman, or you can't fire somebody just because they're a man. We think that's what Congress meant. Now, obviously, we can't go back and know exactly what they meant, but that's one of the devices that courts use is, okay, the legislature, in this case Congress, they make the laws. Our job is not to amend the law. Our job's not to add to it. Our job's not to change it. Ours is just to enforce or interpret what they wrote. If the law should be changed, and this is the big argument on the dissenting opinion, on the minority opinion side, if the law should be changed to include orientation or gender identity, whose job is that, according to the dissenting opinion? Congress's job, right. That's exactly what they're saying. Our job is to interpret the law, to enforce it. Congress's job is to write it and make it. Okay? So the dissenting opinion takes great pains to say, we think that it's wrong to discriminate on the basis of sexual orientation. We just don't think this law says that. And if Congress wants that to be the law, it's up to them to change it. That's the court's rationale for that. One of the, did anybody catch, if you were going to argue, if you were going to take the position of the employer and take the position of the minority opinion, that Congress didn't intend that they didn't write that, what was the best piece of evidence that they cited? Damien.
They cited that Congress had attempted to pass the amendment to that law, but didn't successfully.
Yeah, there's a law right now, they said, before Congress, that they have not passed, that would change Title VII to include discrimination on the basis of orientation and gender identity. What better evidence do we need than the fact that Congress themselves, whose responsibility is to write the law, decided not to? The majority opinion says, yeah, maybe they decided not to because they think it already includes it. I don't know. We go back and forth on that, right? It's hard to know what they would have meant in 1964. So I think that I always find it convenient that when the majority in any Supreme Court case wants to change the law or interpret a law in a new way, they don't have a problem doing that. And then the dissenting opinion always says, oh, you're making new law. That's Congress's job. But then the next time, in future cases, these dissenting justices might be doing the same thing on the other side. So I just think it's always convenient that the dissenting justices are like, oh, you're just making law, and that's Congress's job. Well, that's a common thing to say. Question, yes, sir.
I may be overlooking it, but I don't see any precedent that they mention that supports the dissenting opinion, so to speak. Like, what is the opinion that they're overturning?
Well, so that's a good question, Damien. He was, for my online watchers, listeners, what I assigned you didn't really go into what previous precedent said about this. I actually assigned you an article about the decision and not the actual decision itself. The actual decision is probably 80 or 90 pages or something like that. So, so you're right to be wondering where that discussion is. It's there. I just didn't. It was going to be too much for us to worry about covering. But that's a great question. They would have had to have gone into that some, and they would have given some color to that. But yeah, so that's yet another example we've seen in this class where the law that was written years ago or law that had been well settled for decades ended up being changed by the Supreme Court. All right, any questions on that case? No questions on both sides. All right, let's move on to Clark versus Champion. So, who sued who in Clark versus Champion?
Clark sued Champion.
All right, Mr. Reeves, who is Mr. Clark?
He was like, I think he was like an office worker or something, but he had like worked the medical thing within something. What is that? Yeah, diabetes.
Diabetes, right? Medical
Yeah.
thing being very
Yeah.
broad though.
Yeah, I was sorry. But he had that. I think he also had something with like his skin or something.
Okay.
Or something.
All right, so Mr. Clark worked for Champion. He was in HR training, I think, is what your case said. And he did have, there's no dispute that he did have diabetes. Okay. So, what eventually happened to him, Jackson?
He like was passed out or something, or asleep.
He was sleeping,
Fired.
right? He got fired for it.
When he was at the hospital. Where?
Yeah, they called him at the hospital and told him, peace out, you're fired, don't come back. All right, so Clark thinks that the reason he was fired was what?
Disability.
Disability, that it was discrimination based on his disability. Champion's reason for firing him is what?
That he was
That you're sleeping on the job. Good, all right. So let's talk through then the accommodations that Mr. Clark requested. Because we know that under the Americans with Disabilities Act, that employers are required to make some accommodations for employees with disabilities. And he made several. Who can tell us what one of his claims or requests was? Juliet.
To have a refrigerator that stores insulin.
Yeah, he wanted a refrigerator stores insulin. Did Champion grant that? They did make that accommodation. Amber.
He requested flexibility to leave work to attend doctor appointments.
Right? He said, I need to maybe leave for a lot of doctor's appointments because of my disability. Did they grant him that? They did. That's fine. Is that a reasonable accommodation? Sure. What else? He made some that were not granted.
Yeah, he requested to grow a small beard, and they didn't believe that they didn't grant it because he thought that since he interacted only with fellow employees, he should be able to. They denied it. 3 months later, he comes back and says, here's a doctor's note saying because of my eczema and dry skin, I need to be able to grow a beard. And they were like, well, that's not really a disability.
That's not related to your diabetes, right? They had some problems with that. He also wanted to be able to not tuck his shirt in after he had shoulder surgery, and they had some disagreement over that as well. He was turned in for sleeping on the job before he actually got fired for it. What happened that first go round? Why didn't Clark Champion fire him the first time? Well, that was because they said they didn't really have an eyewitness to it. They didn't necessarily doubt it, but they didn't feel like they had good enough proof of it. So they sort of gave him the benefit of the doubt. The next time, what happened? What kind of proof did they get?
They got a picture.
They got a picture of it, right. And they woke him up. He claimed he didn't know how he got there, didn't remember going to work or whatever, that he thought he might need to go to the hospital. He goes to the hospital. Company decides while he's there that they've got enough finally to fire him, and so they do so. So under the ADA, we know a couple things. You cannot fire somebody based on a disability. You cannot deny a reasonable accommodation. You cannot harass someone based on their disability. So he brings claims for not just discrimination, but also for harassment and retaliation. In other words, he's saying, you were wrong. You violated the law when you fired me because of my disability. You violated the law when you all harassed me because of my disability. And he said the harassment was the back and forth about the shaving and the shirts and all that type of thing. We'll get into that in a second. And then he said you violated the law when you retaliated against me. I complained that you weren't doing me right. I complained that you were treating me differently based on my disability, and then you fired me for it. All right, so he has got really 3 different claims. So as we go through this, the court takes you, and let me pull mine up. The court takes you through the different ways that Clark would have to prove his case. They first talk about direct evidence of discrimination. So I talked to you last week about different ways of proving discrimination. Direct evidence would be like smoking gun stuff, like an email saying, fire him because he has diabetes. Or why did you not hire him? Oh, I didn't hire him because he has diabetes. All right, that'd be direct evidence. What did Clark say his direct evidence was? Anybody remember that? He said his direct evidence was that one email that from the decision maker when they showed him the picture of him sleeping that said, perfect, let him go. So the court says, Mr. Olinger, we are going to take you through some precedent here this time. And they're going to take you through examples of cases where they have found direct evidence of discrimination. Then they're going to compare Clark's claim of direct evidence in that email to precedent. So the first case they bring up is this Portis case. And they say in the Portis case, a demoted bank employee alleging sex discrimination provided evidence of multiple occasions where her supervisor told her she wouldn't be worth as much as the men would be to the bank, and that she was going to be paid less because she was a woman. The court is using that as an example of direct evidence of discrimination. Okay? Then they go to the ETN case as another example of direct discrimination. In that case, the evidence was that the general manager who was responsible for hiring did not allow dark-skinned black persons to handle any money at the casino. And he thought the employee was too black to do various tasks. The court says that's direct evidence. We don't have to make any inference there. We don't have to connect any dots. Okay, we don't have to make any leaps of reasoning or logic. It's all right there in front of it. It's on his face. The Jones case was another race discrimination case where the evidence was that the manager said, good old white boys don't want blacks touching their cards. All right, that was another example of direct discrimination. So then the court says what we have here is an email that says perfect ... let him go. The court says that does not, it's not the same as those other cases where we had direct evidence. It doesn't mention diabetes or any disability anywhere in that email in the same way that the others do. If we were going to make the logical leap that perfect let him go means he was fired for being diabetic, then we've got to make an inference there because it's not direct evidence. So they say Clark's claim fails on the direct evidence part. But we know from our discussion that that's not the only way to prove a discrimination case, because most cases don't have direct evidence. Most employers, even though most people are idiots, most employers don't put in writing or say out loud discriminatory reasons for firing someone. So very often it's up to the employee then to find indirect evidence. So plaintiffs in these cases can also proceed with indirect evidence if they have it. In those cases, remember, it's up to the employee to say, I think I was fired because I have a disability. Then it's up to the employer to say, no, here's the reason we fired you. And then the employee has to show through indirect evidence that that reason is just a fake reason. Okay, that's pretext. It's not the real reason. The discrimination was the real reason. So, in this case, Clark says, I think I was fired for my disability of diabetes. Champion says, no, that's not why we fired you at all. We fired you because you were sleeping on the job. So now Clark has to show all the other indirect evidence he has that undercuts or undermines or disproves Clark's reason. He's got to show then that he was qualified for the job, that he has a disability, and that he had an adverse employment decision. These are things the court lists out for you. Is there any dispute that he had diabetes? Nobody disagrees with that. Is there any dispute that diabetes could be a disability? Nobody disagrees with that either. It certainly can be a disability. Does anybody disagree that he had an adverse employment decision go against him? He got fired. So, all right, we're in the door there. All right, now, in proving that he is qualified for the job, the court tells you that he's got to show, and we talked about this last week, that he could perform the essential functions of the job despite his disability, or that a reasonable accommodation would have enabled him to perform the essential functions of the job. All right? So Champion's argument is, essentially, Mr. Clark, what you're saying is that you should have been allowed to sleep on the job, that that's an accommodation that you requested and that it's reasonable that we should have given that to you because you could do the job even with the accommodation. All right? Champion's response was, that's ridiculous. You can't do the job when you're sleeping. The only job you can do when you're sleeping is a job that requires you to sleep, if you're getting paid to sleep. Right? Otherwise, you have to be awake and alert to do that. So he could not perform the job with or without the accommodation. And so that is why his discrimination on disability failed. Remember, he's still got two more claims. One's harassment. So the court tells you what a harassment case is going to look like, what he's going to have to prove. And they say that he must show that the harassment was sufficiently pervasive or severe enough to alter the conditions of employment and create an abusive working environment. And the court says, here's how we evaluate that. We look at the frequency of the conduct, how severe it was, how egregious it was it just a one-off type thing, or did it happen all the time? Did it interfere with their ability to work? These are the ways that court would assess a harassment complaint. They found then that Clark's evidence of harassment was that they were denying his accommodation requests. And the court says that's not harassment, that's discussion about terms and conditions of employment. We're discussing company policies and how they may or may not apply to you. And that in and of itself is not harassment. Now, if the emails had said something about stop asking for accommodations, you weak diabetic man, okay, that might be harassment. That's different than just discussing work policies. But there wasn't anything like that here. So his harassment complaint failed as well. Any questions on this case? And I am rushing a little bit because I want to get to exam review, but any questions on this? No thoughts, observations, questions on Clark v. Champion? All right. Who won that case?
Champion.
Champion won that case, that's right.
Do you agree?
Yeah, I do. I agree in that case. I don't think that being asleep on the job is any sort of accommodation that they should have granted him.
Yeah.
I mean, I don't even think
He didn't request it either.
he did.
say-
Yeah, he never said I need to be able to sleep.
Yeah.
I think it reads, again, we only know the facts that are told to us. It reads to me like an entitled, spoiled employee who just wanted to be able to do what he wanted and who's a victim.
Yeah.
And anytime somebody denies him or something, it's he's playing the victim card.
Yeah.
That's how it reads to me. I mean, I don't know the exact.
Like, it gets to a point, like, if it's costing an employer more to, like, it seems like it was costing them money for all those accommodations. Because he's probably, so it doesn't make sense.
It was, and
I mean, I don't think that's
because at some point, I mean, Levi, at some point, a little bit of cost or a little bit of inconvenience is a reasonable
fine.
accommodation. At some point, it could become too burdensome
Yeah.
and be unreasonable.
Yeah.
But I don't think after the refrigerator and the doctor's appointment, I don't think that it really falls under unreasonable accommodations. It's just he's trying to get permission to violate their rules
Right.
and stuff. So it's not even like it's going to cost them money. They're just like
And he didn't
We have
he didn't tie those dress code requests really to his disability. He just wanted special treatment.
yeah. I mean, yeah, you got surgery on your shoulder, but like it even said that he didn't have any documentation from the doctor that said he can't do this. You gotta be specific.
But I hope one of your takeaways is if you're ever in management and you've got people who need accommodations, they don't always come right out and say, write you a memo that says I am formally requesting an accommodation that I be allowed, that it's probably something more like, hey, can y'all get me a refrigerator for my insulin or something like that. And we might just be like, you might have a manager that's like, no, we don't have one. I mean, just thinking it was an informal type thing when really it could end up being a violation of the ADA. So you do have to take seriously what your employees. Puts a little bit of a burden on the employer to do some mind reading sometimes maybe and try to read between the lines and figure out exactly what it is somebody's asking for. And it puts a responsibility on an employer to make sure that in whatever communications they're making to the employee, if it's email or verbal or whatever, that you're not saying the wrong things. Just put it in writing, right? And don't try to massage it. Just say what it is, yes or no. We get in trouble when we worry about people's feelings and then worry about are they going to like me and all that. All right, good points. All good points. All right, so let's talk about your exam. It's going to be open, and if anybody has the dates in front of them, holler. I don't have that pulled up, but and as soon as somebody finds it, I'll tell you. It's going to be open around 10 days. I like for you to have the flexibility to do it when you want. Say it again, Juliet. It's due on December 6th. I think that's right.
Yeah, that sounds great.
Say that again, James.
Starts on November 20th.
All right, 24th, which is Monday of Thanksgiving week, all the way through the 6th, which is
like
the
2 weeks.
Saturday. Yeah, so you got 2 weeks to do it. I'm not expecting anybody to do it over Thanksgiving, but I want you to have the opportunity to do it over Thanksgiving if you want. It's totally up to you. I am required to make it cumulative, but I have found a creative way to handle that I'm happy with. I've never been real thrilled with just asking you multiple choice questions about the same things I've already asked you multiple choice questions about in your quizzes. That just seems like a little bit of a waste of time. I'm more interested in knowing what you learned. And so the final exam that I've prepared is reflective. It also gives you the ability to answer my questions however you want to answer them. All right, so I know that's very general. I'm going to read you some from spring semester. And spring was the first time that I did this, so I'm going to tweak it a little, and the questions are not going to be exactly the same, but I'm going to give you a very good flavor of how that goes. So one of the questions that I asked, for example, is, looking back over the semester, what are at least 3 concepts, cases, or discussions that really stuck with you, and why? And y'all hopefully know by now, I'm most interested in the why. And I'm most interested in what you think the why is. I'm not interested in whether you give me the right answer. I want to know what you think and what you've learned. So here's a great answer that I got on this question. I thought the contract section was really important. I knew in the past that contracts are serious. However, I now know more of why they're so important. I know you should fully understand and fully negotiate before you sign. If you have questions, then ask and never assume when it comes to legally binding contracts. Negligence was also an interesting topic to me, specifically the hot coffee from McDonald's. An item that is designed to be hot can somehow be too hot and cause bodily harm. It's important that companies look at something from every possible angle to protect themselves, or else they could be taken advantage of. I think tort reform was also interesting, with it being a current event while we're talking about the course. I think there should be a limit to some of the cases, much like the McDonald's hot coffee case. Some of the cases I've heard about that reached insane verdicts and paid out quite a lot of money. I like that answer. It's not AI generated, okay? It's giving me back what that student learned, what they took away. Awesome. Full credit for that answer. Let me read you one that did not get full credit. The question again was, looking back over this semester in business law, what are at least 3 concepts, cases, or discussions that really stuck with you? This student answered tort law, litigation, ADR. These topics stuck with me because I found them interesting. Okay, 0. Like, that's the opposite of what I'm looking for. So I'm giving you the freedom to answer these questions however you want to answer them, so long as they're your answers and you're giving and they're well thought out. I'll read you a couple more. What did you learn in this course that challenged something you previously believed about business law or ethics? Good answer. The section on social responsibility challenged my perspective on the role of corporations in society. I honestly don't know if I'm for or against social responsibility. My childhood shaped me into the person who is all about self-preservation, so it's hard for me to justify giving up what I have for someone else. If I owned a big corporation, it would be hard for me to give up a percentage of profit for the so-called greater good of society. But there are lots of people who are in need of basic necessities. So regardless of me using selfishness as a safe space, it's obvious why philanthropy is a big focus for most companies. Luckily, I wouldn't be the one running the company, and I have the board of directors, politicians in the local community to help guide the company in making these decisions. Awesome answer. Personal, relates what we've learned, relates it in a way that applies to real life and decisions that he would make. Full credit. Let me read.
Same guy again.
What's something you learned this semester that changed the way you think about business or the law? I would say something that I've learned this semester is how business law and my future career. I realized being in HR, your job is mainly to protect the company. What's missing from those is obviously some thought and effort. But there's no substance. But what's also missing is any why. I'm always much more interested in your why. The answer the student gave about struggling with the idea of corporate philanthropy based on his upbringing, that's awesome. That shows that he listened, that he took something we learned, he applied it in his own life, and he showed me how he thought through that. That's worth more to me than any fact that y'all could memorize to get a multiple choice question right. I'm looking for what you learned and why it was important to you. If you give me AI generated stuff, it's easy to spot, and that makes me read the rest of your exam with an eye of thinking that this is all AI. So don't skimp on any of them. Yeah.
So our final exam, all of it is basically us. You want to hear, like, we just
It's all reflective, but I'm going to give you the prompts. I'm going to give you the questions. So the way I did it in the spring, and I think I'll do it again, is I give you, I mean, it's not short. I want it to be pretty comprehensive. So there were like 13 questions that I required you to answer. And then I did another section where you could choose the questions you wanted to answer. And some of those were a little less involved. So there were a total of, let's see if I can find it. There were a total of, maybe 20 questions total that you had to answer. Again, I'm not looking for you to write a book. Don't think that you need to write 4 paragraphs in order for me to be impressed with it. I could be just as impressed with 1 paragraph as I can with 4, but I could also not be impressed by 1 paragraph if there's nothing to it. Yes?
Is there a time limit when you take the test?
Yes, when you open it, there will be a time limit. It's pretty long. I just don't want people coming in and out of it.
Okay, that's fine.
Yeah, so I think I've given you a couple of hours or maybe even 3 hours. I want to make sure I don't want anybody to feel pinched on time.
Okay.
But I don't want people coming in and out of it because then you can just go and, yeah, you can cheat. So it's a lockdown browser exam as well. So how, would it be an open note and open material? Y'all tell me how you would prepare for that. I mean, you've all got notes. What would you do? Print them out? Would you
Probably just.
print out outlines, or would you go back through your outlines and make your own notes?
Make a list of all the cases. too.
Yeah, make a list of cases, something like that.
Yeah.
Okay.
The main points of each case.
Yeah. So some of the questions I wrote in the spring, the answers weren't great, but I learned that the question wasn't great. So they're not gonna be exactly the same questions, but it's gonna be along those lines. So let me read out some more questions just so you'll have a flavor. What's something you learned this semester that changed the way you think about business law? Was there a topic or a case that you didn't expect to enjoy but ended up really interested in? What made that shift happen, right? So what I'm looking for there is not just, I thought the McDonald's coffee case was interesting and I didn't think it would be before. I want to know why. Why you thought, I get a lot. Well, what I knew about that case was that some woman got rich off spilling coffee, and I thought that was ridiculous. And what I really learned was that all these other things happened, and the McDonald's executives were arrogant. They gave bad answers. I want to know all the reasons what changed your mind. The more you explain your answer, the better chance you're going to have of getting full credit. I'm not looking to disagree or agree with you. I'm looking to see what you think and that you've used something we've learned and that you can analyze it. If you had to explain one thing from this class to someone who had not studied business law, what would it be and why? What did you learn that challenged something you previously believed about business law or ethics? Was there a real-world event, news story, or personal experience that suddenly made something from class feel more relevant? Share what connected. We did that at the beginning of this class. Nick brought up something. What else did we talk about? We had 2 or 3 things. It wasn't just the marijuana and the farm bill. It was, I've already forgotten.
We brought up-
Oh, Epstein.
Penny.
The penny. There you go. All those things could be tied into stuff that we've learned. So I'm all for that. So maybe between now and then, you'll see things or you'll think back on things we've studied and be like, oh, I could use that. Or that might be a good thing for me to use. I would probably go back through your notes. If you've taken notes, you can print those out and obviously use them. I would also probably go back through the outlines maybe and just jot down things that were interesting to you or that would remember that would be helpful when you're doing this exam. I don't want you to be like having to pull it all from your head. I think that would be a little harder to write a good, thoughtful exam answer. So if you need to make notes and take prompts and things like that, it's fine. What is one concept, rule, or principle that you think from business law that you think every adult should understand? Why? If you end up working in business, how do you think something from this class might help you avoid a legal mistake or make a better decision? Which legal case or topic raised questions for you about fairness, justice, or ethics in the business world? How do you wrestle with those questions? If you could rewrite or change one business law, what would it be and why? These are just examples. These may not be the exact questions. But what I would love to get is exactly what Nick did at the beginning of class. I've written a business plan, or I've thought about a business plan for X business. And now this has changed legally. And here's how everything we talked about in this semester affects what I've planned or what I know or what I've learned. That's incredible. That's what I want y'all to take away from this class is ideas and concepts that you can use, not just facts to memorize. I want you to actually have learned something, and so I'm hoping that by doing the exam this way, you'll be able to give that back to me and demonstrate to me what you've learned. Anybody have any questions?
It's all like answers.
All short answer, 100%. Let's see. Have you found yourself explaining something from this class to a friend or a family member? And if so, what was it and how did that conversation go? Hopefully everybody's done that. It might not be like, yeah, I can't wait to tell you what I learned in business law. But it might be like, you're not going to believe this BS that I learned in business law today. Get a load of this. Think about who you were, where you were on the first day of class. How have you grown in your understanding or perspective of the legal stuff since then? Everybody should be able right now to write me 3 paragraphs on that without really even having to think about it. I liked this one, and I am gonna ask it again. Where is it? What was the most important thing you wrote in your personal code of ethics? Why did that stick out to you, and what will you take from that? I'm going to ask you that question. So review your personal code of ethics. I like the question, describe a moment when you realized you were starting to think like someone who's taking a business law class, right? I had a student answer this in a way that said, it was a Chick-fil-A employee, was like, after the McDonald's hot coffee case, all I could think about for the next week was not spilling something on somebody or, not noticing water on the floor. Everywhere I looked, I was looking for negligence. Things like describing all that sort of thing. Again, the more you can explain the why, the more points you'll get, the more I like the answer. Anybody have questions on that? All right, so to recap again, we do not have class Tuesday. We will have a speaker next Thursday at the 11 o'clock class, so we will not meet at 9:30. If you can come to the 11 o'clock class, that'd be awesome. It's going to be in the auditorium on the main floor. Will not be up here. You have a quiz due Monday on employment law. You have an assignment due Monday on the guest speaker from Tuesday. Anybody have questions? Have a good weekend.